Well, thank you so much. It is a real honor to present to so many people who are on my syllabus. I'll just run you through some key points of the paper to illustrate some of the key topics that strike me about this project. So in order for originalism to be good or true, it must reject what is bad and false. And I'm here today with a tale of originalism gone awry. So you may have heard that the Fifth Circuit has declared yet another federal law unconstitutional, this time on originalist grounds, saying that Congress unconstitutionally handed off its power of the purse to the executive, an agency known as the Consumer Financial Protection Bureau. And this decision is a flawed originalist analysis, and the flaws in this analysis have broad ramifications not only for many important funding decisions in government, but also for originalism itself. So the underlying constitutional concern here again turns on one of non-delegation. Article 1 of the Constitution assigns Congress the power of the purse, and critics say that Congress impermissibly handed off its power of the purse when it passed an open-ended funding law that allowed the Bureau broad discretion to self-direct its budget. Now, there are different theories as to exactly which provision of the Constitution this structure violates, whether it's the Appropriations Clause or some other part of the Constitution. But at the end of the day, I think all of these theories lead to the same result. And critics essentially claim that Congress shirked a constitutional duty to pass a law that further specified the specific amount that the Bureau could spend, the source of its funding, and also the duration of its funding. Initially, you might be surprised to see this claim if you think about the text of the Constitution. I mean, the Appropriations Clause merely says, "No money shall be drawn from Treasury but in consequence of appropriations made by law." And it seems like Congress did that here because it passed a law authorizing the Bureau's funding. And indeed, that law didn't even come close to touching the only constitutional limit on the duration of funding for an army. So I think in this particular case, the case against what the Bureau did as a constitutional matter is one that draws not really from text, but strongly pragmatic enrichment and history. So the Fifth Circuit leaned very strongly into history when it claimed that the Bureau's funding structure was an abomination of which the framers warned. My thesis is that originalism does not support this result. History is instead on the Bureau's side, and judges who do not recognize the import of the broader historical record are cherry-picking, engaging in law office history, and undermining the constraint that originalism is supposed to impose. So I'll unpack this thesis in two main parts. First of all, I'll walk you through the Fifth Circuit's selective understanding of the historical record and much of the evidence that it missed. And second, I'll turn to the additional puzzle of why, at least at oral argument, the Supreme Court justices, or at least not all justices, seemed poised to reverse the Fifth Circuit after seeing clear historical evidence to the contrary. So for part one, what did the Fifth Circuit do? I think in many parts its analysis illustrates how hard it is for courts to do originalism without the support of additional briefing, especially from scholars who are in a good position to really flesh out the historical record in more detail than parties to litigation may be able to do. So here, while the Fifth Circuit relied on some standard originalist sources, it looked to the backdrop of English history. It considered some of the early appropriations laws. There's a lot of evidence that it missed. And two key categories of evidence that it missed are evidence of the Constitutional Convention, as well as evidence of laws passed by early Congresses. So with respect to the Constitutional Convention, I think the pattern of debate and evolution of the Appropriations Clause here shows that the delegates opted for durable revenue and spending powers. And when they wanted to impose temporal limits on spending, they did so expressly, as in the clause that limited appropriations for the Army to a period of 2 years. They did not include any such temporal limit on the general spending power. In addition, early Congresses just repeatedly passed laws that bypass the supposed limits on the Bureau's funding, or the supposed constitutional limits on the Bureau's funding. So these early laws were often very generous and directly violated many of the supposed limits claimed today. So some of the most generous funding provisions in the founding era were those given to an agency known as the Sinking Fund Commission. The Commission's main job was to make open market purchases of US securities in a way that would both prop up their value and repay the debt. And the initial funding award to the Sinking Fund Commission was extraordinarily generous. In current terms, it exceeded $250 billion. And in addition, the authorization that the Sinking Fund had for its open market purchases was indefinite, and it was able to self-direct the amount of this $250 billion it was given to spend. So within a few years of the Sinking Fund Commission's operations, Congress further awarded the Commission funding from interest generated by its purchases of debt. This particular interest-based funding is essentially the same as the independent funding that the Bureau receives from the Federal Reserve today. Beyond the Sinking Fund Commission, the historical record is just replete with additional examples of standing self-directed compensation for a majority of initial federal officers. So customs officers and US attorneys could self-direct the amount of fees they would recover by deciding how many forfeitures they wanted to seek or how many prosecutions they wanted to bring. And in many cases, these fees were paid outside of common appropriations. They were paid by offending parties rather than Congress. So here, I think the historical record, when you look at it in more full fashion, makes clear that the Fifth Circuit was wrong in its conclusion that the Bureau's funding structure violated original understandings of the Constitution. In fact, this evidence was so strong that General Prelogger based her defense of the constitutionality of the statute on text and history. Also noteworthy, I think, is that in the amicus briefs, a group of law and history scholars filed on behalf of the government. But unlike other cases where we've talked about scholars who may have different views of originalist takes on the unitary executive or non-delegation, there was no group of law and history scholars who filed an amicus brief on behalf of the Fifth Circuit. So, and this moves to part two of my presentation, you might think, well, moving into the Supreme Court's argument, isn't this an easy case? And shouldn't the Supreme Court just strike down what the Fifth Circuit did? And I know. And after oral argument, it's not so clear that that is going to be the case. And there are a number of reasons and questions that went back and forth at argument, some related to burden of proof, but really, I think the key problem here was a line of questioning raised by Justice Alito. And he really seemed to insist that the government, in order to show that the structure was constitutional, that it must prove a fairly specific historical analog to the Bureau's funding structure. And this seems analogous to something that Second Amendment scholars have referred to as originalism by analogy. And again, the idea here, I think, mixes and matches historical and precedential modes of reasoning and says basically in order for a modern day law to be constitutional, it has to have a relatively precise antecedent in the historical record. Justice Alito seemed to apply this approach when he pressed the government for the single best example of a historical analog with the Bureau's combination of funding features. And when General Prelogger came awfully close with the Customs Department, he just asked for an even more specific analog. So this mix of historical and precedential analysis is one that I think is especially bad for structural constitutional questions. It places undue weight on structures, first of all, that early Congresses chose not to enact, even though we know in the structural realm especially, Congress may not enact structures for discretionary reasons that have nothing at all to do with their constitutionality. In addition, originalism by analogy excludes really important evidence of very similar laws that early Congresses actually passed. So the laws on funding for the Sinking Fund Commission or other fee-based officers may not be a direct on all fours precedent, but they are still very close and worth considering. So all in all, the framework applied by Justice Alito seems to focus on what early Congresses did not do and ignore what they did. And this seemed to lead him to the same erroneous understanding as the Fifth Circuit. And this approach, overall, if it's not reversed, raises grave doubts about originalism and the constraint that it is supposed to impose on judges. Thank you.
I think Christine's paper, although they typically diverge in their conclusions from what most originalists conclude, they speak our language, so to speak. I don't think she's an originalist, but her work demonstrates where the conversation now is. And that's, I think, a far cry from 15 years ago when this conference started. On the topic at hand, the CFPB's funding structure, it's a bit hard for me to comment on this paper because I think it's right, at least as far as it goes. And where it goes is more or less where the Fifth Circuit went. The meaning of the Appropriations Clause and the historical examples of fundings and appropriations at the founding. My concern is that I don't think the Fifth Circuit was analyzing the right question. And as a result, I'm not sure Christine's paper is responding to the right question. Now, that's not her fault. That's the Fifth Circuit's fault. So let me explain what I think the right question is, and hopefully it won't be too orthogonal to the topic at hand. Okay. So the right question, I think, isn't what the meaning of the Appropriations Clause is, because the Appropriations Clause here isn't the grant of power, it's the restriction of power. It provides that money can't be drawn from the Treasury without an appropriation, but here, in the CFPB case, no money is being drawn from the Treasury, so that doesn't seem to apply. But even if it does, and it might, because perhaps Federal Reserve funds are automatically part of the Treasury for constitutional purposes, there, I agree with Christine, there is an appropriations made by law, saying the agency may spend up to X amount of a certain pocket of money in order to discharge its various authorizations seems little different from early lump sum appropriations in the Federalist period that Christine and David Curry and others have previously highlighted. Of course, there is a difference here in that the source of funds is such that they never expire, and it takes an affirmative act of Congress for them to expire. I do think that's a bit different, but it doesn't seem to be a difference that matters under the Appropriations Clause because, again, there has been an appropriation up to 12% of a certain pocket of Treasury funds. So I think I generally agree with Christine if the question is the meaning of the Appropriations Clause. However, it seems to me that the real question is, where does the power to spend come from? We aren't talking here about the power to spend for the general welfare, even if there is such a power. That's an uber textualist should be skeptical of that. Rather, the power at issue is the power to appropriate or to spend under the necessary and proper clause. Now, that all seems quite obvious to me, and I'll try to unpack it again, but I don't begrudge Christine for talking about that. I just want to emphasize that the two principal Fifth Circuit opinions don't even mention the clause once. The principal brief in the Supreme Court does not mention the clause at all either. No one is talking about the necessary and proper clause, even though it seems to me that that's the clause at issue. Okay, so how does it work? As those here know, the clause is a grant of implied powers and can't be interpreted to grant great, important, substantive prerogatives. At least that's the claim that originalists tend to make. For example, if the power to tax had not been given expressly, one can't deduce that power from implication under the necessary and proper clause. But the power to spend the money that one does have, whether from taxes or selling public lands or borrowing or pillaging and plundering, does not seem a great and important prerogative, so long as the spending is in pursuant to an enumerated power. In other words, if Congress can establish post office and post roads, surely it can pay someone to build the roads and the post offices or pay to acquire them and so on. So once we locate the power here under the correct clause, it seems to me that a lot that was obscured in the analysis is clarified. Start with the specific appropriations of the Jeffersonian era. Are those appropriations necessary and proper for carrying into execution the enumerated powers or the powers of the executive branch in executing Congress's laws? I think so. Line item appropriations for this or that post road are obviously necessary and proper and perfectly incidental. What about the lump sum appropriations from the Federalist period? Does that raise a non-delegation concern? The first thing, as I'd suggest, as others have before me, including prominent folks here, is that there is more leeway in delegating this appropriation power, by which I mean Congress can grant the executive broader discretion. Why? Because by hypothesis, the power to spend in order to successfully execute specific authorizations enacted pursuant to specific enumerated powers is not a great and important prerogative. It's incidental. That's why it can be implied from the necessary and proper clause. Well, if Chief Justice Marshall is right that the non-delegation doctrine is concerned with important subjects, right, then I think by definition, power derived from the necessary and proper clause is less important, and therefore more amenable to delegation, by which I just mean broader standards. That the Federalists made lump sum appropriations seems okay to me because they decided all the important questions, what the money would be spent on and the specific authorizations, from where and how the money would be raised. They put limits on how much could be spent. They can be forgiven for failing to waste their time breaking down exactly what post office needed what sum of money. Okay. Now I think the clause also sheds light on Christine's examples in her paper. Working backwards, we have patent application fees that fund the work of the patent board. That seems sensible. Before the grant of a public privilege, you can be made to pay a fee for considering your claim. This seems incidental to the power to grant the privilege, hardly a great and important prerogative that can't be left to implication. I'd also say, by the way, of course, no money was ever drawn from the Treasury. It was collected by private parties and sent to the Treasury, so surely we can't complain about that. I'd say more or less the same with respect to the success fees for the U.S. attorneys or U.S. marshals. Such fees were not created to insulate them from congressional scrutiny, but as incentives to execution of the law. If you only get fees for successful prosecutions, that encourages you to prosecute people for offenses, encouraging faithful execution. Zach Price has written a bit about this. And it discourages dubious prosecutions because you're wasting your efforts and you aren't going to get paid. To be sure, there are downsides to this approach, and the profit motive was eventually eliminated, but that system seems rather innocuous to me. Under the necessary and proper clause is intended not to insulate, not to create bureaucratic independence, but rather to create proper incentives. That seems necessary and proper for carrying into execution the president's power of faithful execution. Okay, I would add also here, of course, that these fees are taken from the Treasury, but they are also paid for through general appropriations as far as I'm aware, right? So again, no appropriations clause violation, not spending clause appropriations clause, not necessary and proper appropriations violation. Okay, that brings me to the sinking fund. I do think this is harder. Congress appropriated funds to the Commission to take certain actions with respect to the public debt, and the actions themselves generated interest, and therefore additional funds for the Treasury. They were initially given discretion when to buy down the debt. Of course, that makes sense. When to buy it down and when to hold it are decisions that have to be made day to day, depending on market conditions. As long as Congress sets the general principles, which it did, this doesn't seem to be a problematic delegation. It seems to be perfectly appropriate under the necessary and proper clause. And I would say it's appropriate under that clause that if you make interest off of the activities, that you can use the interest to continue to pay for those same activities. At least that's not a crazy thing to think, especially when the activity has a specific endpoint, namely paying down the debt. So that's the precedent. Now we fast forward to the present day and the Bureau of Consumer Financial Protection. The CFPB doesn't operate under the profit motive. It doesn't obtain fees for successful prosecutions, and frivolous prosecutions aren't discouraged, so it doesn't set up any sort of incentive structure that's necessary and proper for faithful execution, nor does it collect fees for the privilege of processing some voluntary claim for a public right. Finally, it isn't authorized to utilize the money that it earns on its activities to continue those activities in the same way the sinking fund did. All of this is to say is that the CFPB is new. It is novel. It's a freestanding agency whose regulatory and enforcement activities are entirely funded outside of fees that it collects for voluntary and non-coerced services, outside of fees from convictions and penalties that it secures. It gets money that another agency that is more like the sinking fund, the Federal Reserve, generates on its market activities, and that Congress has to affirmatively disapprove in the future, which would require presidential signature. Although many early appropriations were for several years, Congress still had to have the money on hand. Perpetual appropriations outside of the interest-generating context were literally impossible because you can't know how much money you're going to have on hand going forward. So to be clear, I don't think this scheme violates the so-called appropriations clause. No money is being drawn from the Treasury. And if it is, the withdrawal is authorized by Congress. So I'm not sure why this clause would be implicated. So I agree with Christine on the fundamentals here. But the question, it seems to me, is whether erecting this scheme, whether setting up an independently financed regulatory body without the limitations and incentive structures of early precedents, is merely an incidental power that Congress can properly exercise under the necessary and proper clause or not. I actually don't know the answer to that question. But what I do think I know is that all of the Fifth Circuit's historical evidence is just as relevant to that question as the important historical precedents that Christine's paper intelligently and coherently presents. And I think that's all I really want to say. Thank you.
All right, thank you so much, Ilan. And just a few quick reactions. One thing I wondered about this paper is, to the extent we're talking about original public meaning, originalism, is it really based on people thinking about what an appropriation means, or does kind of the historical analysis move fairly far afield from that? And I think one of the interesting points then is there's some difference, as Ilan has pointed out, in terms of, well, what exactly constitutional provision might you think this structure violates? And is this really moving toward a situation where, at some points at least, we need to have original public meaning also be complemented perhaps by original law originalism, because it's really thinking about the original laws and the ways that those laws shed light on what structures may or may not have been constitutional. And I guess for me, no matter what constitutional specific provision you find, I'm not sure that the Consumer Financial Protection Bureau today is a leviathan any more than some of the agencies that we had at the founding. I mean, especially if you compare the very generous amount of the Sinking Fund Commission's initial funding, indefinite power to self-direct a budget that, again, in current terms, would exceed $250 billion. It seems that we shouldn't be so worried about the Consumer Financial Protection Bureau's capped power to spend indefinitely something around the neighborhood of $600 million. But so I think that the analogy holds up and maybe shows that what Congress has done with the Consumer Financial Protection Bureau is, at least in material aspects, nothing new or nothing that we should worry about in particular as a violation of the Constitution, no matter which provision of the Constitution you might rely on to support that theory.
So, two suggestions. The first suggestion is that you say something about the original public meaning of the constitutional text. So the appropriations clause uses the word appropriation, and the paper says nothing about the meaning of that word. And so, I just did the cheap and dirty things one can do preparing for a conference. And appropriation has, including legal dictionaries and general dictionaries of the period, it doesn't have this modern sense when we talk about an appropriations bill, that an appropriation is simply a statute that authorizes the spending of money. The sense of appropriation that is in Bouvier, Johnson's, and Noah Webster's, I'm not advocating this as a method, but just allows us to get at the issue, is very much about a targeting for a purpose. And so I don't know where this leads. I just think the paper should say something about the constitutional text to the extent the paper is criticizing the decision from an originalist perspective. I understand that the existing judicial commentary may also have nothing to say about the text, but that might be important to note too. Just the second thing is I just don't think that when Alito is proposing sort of a history and tradition historical analog test, that he's doing originalism. And I don't know why you would think that, right? Alito describes himself as a practical originalist, and I think the best reconstruction of what that means is that he's a constitutional pluralist that considers text and a bunch of other things with a heavy emphasis on historical practice. So if that's his theory, you really, it's a misplaced criticism of originalism to say someone who's using a non-originalist methodology is doing bad originalism.
First, on the text question, this is also Blackman-Tillman kind of text. The offices of profit, right? What kinds of offices? So if we have offices of profit, office of trust, that's another textual hook for this, right? Because it's sort of Perillo's dichotomy, where you have this long-standing tradition of offices of profit, and that English tradition is that they were self-financed. And so that, and then you've got these offices of trust. I'm projecting this on, but even when you have, there's another problem textually with appropriations is that we also have the compensation clauses. Congress doesn't have control over, once they appropriate compensation under Article 2 to the president and to Article 3 judges, those are locked in, they can't diminish them. So they have bound, it is Congress appropriating, but Congress has bound future Congresses on appropriation, so that limits a current Congress's discretion has now been limited by past Congresses locking in. So there is already in the text of the Constitution both this salarization, but fixed compensation that limits Congress's discretion. And you've got, but so, okay, so then we have the offices of profit. That comes to Ilan's question where, okay, if you have these offices of profit, they are independently financed by their own fees and bounties, right? And then you've got maybe the problem that Ilan is spotting here is when you have appropriations, that discretion is limited to that and is required for the formal kinds of offices that do domestic policy with salaries, whereas the constitutional structure in Congresses have let other officers just be privately financed, and that's not an appropriation problem. I think you have an answer to Ilan there, because that this is maybe tapping into the Spirits Act, not the spirit that Cy's talking about, but the alcohol spirits. You have a bunch of examples. You have a bunch of examples that address Ilan's question, because there is not a dichotomy anymore as the sinking. So the examples that you give, I think you should emphasize this, that there's a mixedness, like mixed drinks, if you will, right? Sorry, I'll stop the puns there, but there's a mixed, your examples that show a mixing of public responsibility or public financing with the private structure, that implicates the questions you're raising here, because that is not privatized. That is saying Congress will do a mix of private fees and bounties, but Congress will also appropriate to make sure that in the future that those, with discretion, that those offices can function. So between the Spirits Act, the Process Act on page 52, the U.S. Marshals, your sinking fund, and I think the DOJ, there's no DOJ, so I think the example of the U.S. Attorneys is another example of that mixed finance system for you.
So I had two thoughts. I got Cy's response to me from before ringing in my ear, so maybe feel free to say, well, that's your paper, but I'm not going to write that paper. So here's two papers you might think about writing. I guess I'm just curious, because you've canvassed this stuff, just what you've learned about these two things. So one I think would be nice to have theoretically would be a set of criteria for making Silver Blaze type non-barking dog arguments. So it seems like sometimes those kind of arguments are pretty powerful. So like, there's no anti-federalist, as far as I know, that complains that the commerce power is going to make the federal government omnipotent. There's lots of people who claim that the Article 1, Section 8, Clause 1 will, lots of people that say the necessary and proper will, but that seems like pretty good evidence that the Commerce Clause has got to be, relatively small. Stuff that Washington at least thought about and then didn't do, even though you really think he would have had incentive to consider. So when there's silence, I think it would be great if we had, just as a theoretical matter, a set of criteria for when those non-barking dog arguments work. Second thought I had was about non-delegation aspects of the funding business. So here's a rule, and again, I just haven't canvassed the 1790s stuff. I mean, every time these papers come out, I'm like, oh, I'd have to read even another few hundred pages of that to really feel like I'm even knowing the literature. But here's a rule that might have some historical support. Who knows? If Congress could do it, it has to. So Madison says something kind of sort of maybe like that in the report of 1800. Ilan, a few hours ago, told me that maybe somebody may have said something like that in post-Rhodes debate or something like that. So why do you have to have an executive? What are the characteristics of executive action? Secrecy and dispatch. You got to move quickly and you got to move secretly. You just can't do it in a legislature. Well, any notice and comment regulation that takes more than a year could have been done by Congress because it's notice and comment, so it's public, there's no secrecy, and it's taken more than a year, so Congress had to have met under the 20th Amendment. They got to meet at least once a year. But all this money stuff that you're talking about, well, there really is a need for secrecy, or at least vagueness about, like, well, what are we going to do? You don't want to bind negotiators about exactly how, you don't want to tell people in advance, I must build a McDonald's right here. I mean, McDonald's, when they buy land, they don't tell people that they're McDonald's. They're secretive. So giving Washington discretion about, well, just build a post road somewhere, but don't like pass a statute saying we must get it through this particular dude's farm, right? So this would be a way where you could tear down 90-some%, 98% of the modern administrative state, but all of your stuff would be perfectly constitutional. So I guess the question is, did anybody in the 1790s say anything at all like that?
All right, so those are great questions. Thank you. There are a lot of broad things to think about. So first of all, Larry, thank you for the idea to focus more on the text. One thing that you brought up that I think is maybe a theme of Chris's question is the idea of having a purpose to constrain spending. And I think that ultimately goes toward the idea that maybe if you're thinking about non-delegation, it's not just a delegation of power to spend, but there does always have to be a purpose for which spending is intended, and that's an important constraint, even if the money is very generous. One of the reasons is maybe just to make sure that the executive doesn't feel free to take that money and spend it on an army. I think that was the greatest fear. A standing army could really lead to tyranny. That's why there's the 2-year limit on appropriations in the Constitution. So that idea of purpose is one that's going to operate as an additional constraint. It may not necessarily be in the appropriations bill, but there would be a separate authorization bill that should limit the agency or executive actor to some sort of purpose in that context. And then, yeah, Jed, important points, I think, on this, the hybrid nature of the funding that definitely existed at the founding. So the early U.S. attorneys, initially they might be fees that were in various ways collected from people who lost lawsuits, criminal lawsuits, and then Treasury shifted over to taking some responsibility for that. I think one of the questions, I'm not sure if this is exactly, Jed, what you and Ilan are getting at, is the question of, well, should we worry at all about an appropriations clause violation here? Because a lot of the money we're talking about is not drawn from Treasury, right? The CFPB's money comes out of interest earnings of the Federal Reserve System, so it comes out of that separate set of funding, and it's not something drawn on Treasury. I think the answer there is actually that when the framers drafted the Constitution, there was not yet a Treasury Department, right? There wasn't an actual Treasury. I think the concept might be more one of public funds in general. That was a point raised at oral argument by General Prelogger in the CFPB case, and the idea that maybe things like forgiveness of student loans, for example, that's not an appropriation drawn from Treasury, but it might still be of concern, I think, if Congress didn't authorize that spending at some level, perhaps, right? Because forgiving debts owed would be at some level an expenditure of public funds that we might think about in the same framework.
But there,
yeah.
Under the article, there was a kind of proto-treasury under the Articles of Confederation. There's no executive branch, but there was this kind of three-headed system. So I don't know enough about it. It might be just to connect those dots might help. Yeah.
So there might have been, I think if there was something there, it was very minimal, right? They were broke. So maybe there was an earlier, maybe there's something left in terms of earlier funding, but I think a lot of it was, the earliest laws passed were all these revenue-raising laws to allow us to collect customs because we had no money. We needed to rake it in somehow, right? So I think there was an idea that there would be this new, better financed, hopefully, body, but that is a good point, that there was probably something pre-existing, some funds, but definitely not enough to meet all of the current U.S. obligations. And then final point, Larry, I'll think more about. I think that's a good point. Like, is Alito doing originalism? And I guess for me, what resonated with what Alito was doing is I thought it was very similar to some of the analysis in Bruin, the Second Amendment case, which I think is doing originalism when it has, what some people referred to as a originalism by analogy framework, and that maybe that raises a question of, are they not doing originalism, or I think it's a problematic way to do originalism because it does really seem to combine this idea of precedential reasoning, kind of the way lawyers would require a fixed set of precedents to support a different particular decision, applying that type of requirement to the historical record, saying you have to have something that's relatively precise in the historical record in order for the statute to be constitutional. That's my understanding of how that test might be applied in an originalist context in, say, the Rahimi case, for example. And I think, to me, that also seems to be what Justice Alito was doing in this case, but maybe it should be something that's rejected as a use of history that is not consistent with originalism because it is so selective. I think it's just another form of law office history, so maybe I could be even stronger in how I word that particular critique.
Great, thank you. Our next group is Will Bode, Steve Sachs, and Adam Griffin.
Thanks. So I totally buy the Appropriations Clause claim. This is not a violation of the Appropriations Clause. And I think I also buy the claim that it's not a violation of the non-delegation doctrine, but I would like to understand more about why, and especially whether on your reading of the history, is it because there was no non-delegation doctrine, and so it didn't violate the non-delegation doctrine because there wasn't one to violate, sort of a Mortensen and Bagley thesis? Or do you agree more with Ilan that there is in general a non-delegation doctrine, but spending clause statutes for whatever reason, or spending for whatever reason, is sort of really hard to violate it, kind of contra the Nebraska versus Biden, McConnell brief in Nebraska versus Biden, et cetera, so which of those two is right? And one hypothesis about the latter is it possible that spending is actually a form of executive power? So there's a John Harrison article about the executive power where he has a very minimal definition of the executive power. He rejects a lot of the royal prerogative thesis, but he says one of the things that was the executive power was the ability to spend the resources of the United States, subject to the constraints of law. So the Appropriations Clause is important because it restrains what would otherwise be the executive power to take the money in the till and do stuff with it. I don't know, is that relevant to why this is not a non-delegation doctrine? Do you have another explanation, or what do you think is going on?
So thanks very much. I really enjoyed the paper, and I know nothing about this area. So I apologize if my question seems really ignorant. What's an appropriation, and what's the Treasury? And the reason I ask is, we were talking about this at lunch, suppose that the Congress says, you know what, it would be great if our schools have all the money they need and the Army needs to hold a bake sale to buy tanks. So what we're going to do is empower the Department of Agriculture to grow apples and wheat and make pies, and then they'll sell them, and all the money can go to the Defense Department. And they can do this ad infinitum. Is that an appropriation from the Treasury that's in excess of the 2-year rule? Does any money, when it comes into government hands, become in the Treasury? What if Congress, said all the money you make from Army-Navy game tickets, you can use that, and if you create a GoFundMe and people just send you money, you can. We have the Anti-Deficiency Act, but they didn't have to. So what counts as an appropriation? And is it that, all of these things would be end runs around the 2-year rule, but we just have to understand that appropriation is its own thing and that fees aren't really sort of appropriated at any real point?
Hello? Okay. Sorry, mine doesn't have the LED, so it's hard to know. Great paper, really interesting and engaging. I had 2 quick question points. One, kind of in light of Sai's paper from the last turn, there was a lot of spirit arguments here about limitations on the Appropriations Clause. And I kind of wondered if maybe those arguments were given short shrift in the paper. So the Appropriations Clause seems sort of unlimited on its face, perhaps. But the freedom of speech shall not be abridged, or the right to keep and bear arms shall not be infringed. Those are kind of categorical statements, and yet we seem to find limiting principles from background historical material, from other things. We tend to find limiting principles. So I'm wondering if these spirit arguments from James Madison and from others might carry more weight in terms of what is the limiting principle. So is there some kind of implementing doctrine, or is there some kind of purpose-driven constraint? And I'm wondering sort of what what your proposed limiting principle on the appropriations clause is and where it comes from. And then also, this is kind of piggybacking on Ilan's point, but I'm wondering if there really is a category difference between these founding examples, which are draw money from a sinking fund to pay debt, money that comes from another source to pay salaries, versus something like the CFPB that seems much, much larger in terms of get an independent funding source that you can self-fund and regulate an entire body of the economy. Something more like a Schechter something more like a Panama refining, where it's, fund yourself to regulate an entire area of the economy rather than here's a funding source to pay a debt, here's a funding source to pay a salary. If there's something categorically larger about the kind of regulatory authority the CFPB is exercising from this external funding mechanism.
Right, so thank you. All great question. I think going in somewhat different directions. So yeah, in terms of whether funding, is something we should evaluate as a violation of the non-delegation doctrine, I mean, I think that's definitely the theory, right? Because Article 1 assigns Congress the power of the purse, maybe not expressly, but I think everybody agrees that that is Congress's power assigned, and then it can authorize spending by the executive, and we might disagree or argue about like what types of purposes we could authorize spending for, but basically that's something Congress has the power to do. And is that a problem under the non-delegation doctrine? And I guess the reason that spending hasn't often seemed like a problem under the non-delegation doctrine is that it is often something that's accompanied by a limitation on the purpose of spending. So there's not just a law saying, spend whatever you want on whatever you like. It is always spend whatever, up to this amount perhaps on some particular purpose. The purpose is set down, and I think that satisfies at least the modern intelligible principle doctrine. My work, The Lost History of Delegation at the Founding, I say that, I guess in between Ilan and Mortensen Bagley, that there was a non-delegation doctrine at the founding, but it was pretty close to the intelligible principle doctrine, so not something with a lot of teeth. And I think, for me, the interesting thing there is that even some of the scholars who were urging, or maybe Justice Gorsuch urging, a stronger non-delegation doctrine to regulate private conduct seem to recognize some kind of exception for public acts, and spending is more of a public act. It doesn't regulate anyone's private conduct. So to me, there was some consensus, I think even amongst scholars who, and I think maybe parts of Ilan's paper, which he hasn't disagreed with that, part of my analysis today, where even if you would push or advocate for a more rigorous non-delegation doctrine, you might still not think that applies necessarily to spending, because there will still be limits on substantive authorization that has to accompany the purpose, or kind of define the purpose for which that spending can be done. And I think it's an interesting point whether, to what extent does spending constitute a type of executive power? I think perhaps discretion over spending might relate to some understanding of executive power if you go to cases like Lincoln versus Vigil, or something like Heckler versus Cheney, where there's discretion, not to prosecute perhaps. Is that a discretion of how you want to spend funds allocated to you, prosecute certain cases but not others? And does that type of perhaps allocation of resources at some level touch on an executive power? You would still need an initial law from Congress, but they might not need to micromanage, I suppose, how that kind of spending is allocated. Then turning to the second questions of defining appropriations and defining treasury. So for appropriation, I guess, I still need to maybe add some more thought on the textual meaning of that, but I do have in my paper a definition that was proposed by Alexander Hamilton. I think it hits on the important parts, is that appropriation for him is a law in which Congress has identified the purpose, the limit, and the source from which funds are to be drawn. And if that happens, then I think an appropriation has been made. Basically, that would be his definition. I think that is something that's consistent with both the historical record, and I think the CFPB's funding has a limit. It's got a cap limit. It has a source from which funds are to be drawn, and it has a purpose. In addition, what is Treasury? I think the definition of Treasury is not is something that probably was a little more general at the time of framing. I think it is properly read, or best read perhaps, to be thought of in terms of public funds. Now, part of this might be shaded somewhat in terms of maybe not so much originalism, but just in terms of modern construction. If you, say, well, Congress can just, impose fees on different people, and that's not really something coming out of Treasury, so we're not worried about that as an appropriation, then there could just be huge loopholes for appropriations, and requiring that to be something that follows the requirements of the Constitution. So maybe that's kind of also what shades that definition. But I do think that's the tack that the Solicitor General took at oral argument in this particular case. And I think that's probably the right definition, not to say, it's okay if it comes from some other source. You still might worry about, I guess, ultimately the purpose. If the purpose is one that is directed at spending on an army, then I do think that the 2-year limit applies. And maybe even, the example you gave would be a ridiculously underfunded army, not something that is going to create the type of standing army or fears of tyranny that the framers would worry about, but nevertheless, something that would still, I think, be limited to that 2-year limitation. And then final question in terms of, there were some examples in the paper of not only the Spirits Act, but Madison talking about the spirit of the Constitution and how that would apply to a proposed limit, not on spending per se, but on the duration of a revenue law. And interestingly, after hearing the opening paper, I think that he was using that in terms of a constitutional construction rather than an interpretation of the Constitution. And I think the understanding to take away from that particular exchange is that, look, the Appropriations Clause is pretty open-ended. It leaves a lot of matters of funding to the discretion of Congress. And often in areas of the structural Constitution, Congress just does have a lot of discretion in terms of how it is going to set up funding structures. Does it want to micromanage? Does it want to specify the amounts that the executive can spend on particular items? Or does it want to give a general lump sum? That's just something that's left to the discretion of Congress, and I think that's consistent with the historical record. And then I think I would characterize maybe your final comment on comparing what happened in the past to what happens today as maybe kind of a Humphreys executor squared problem, because maybe the problem for people worried about the Consumer Financial Protection Bureau is not just that the delegation of spending power is very broad, but also the overall purpose or kind of substantive statutory parameters for the Consumer Financial Protection Bureau are very broad. And maybe that's where more of the Leviathan concern comes in, not just its funding, but what is unfair, abusive, or deceptive practices, and a lot of power to determine how it's going to enforce the law. Is that a concern? And I guess from my perspective, reading from kind of thinking carefully about the separation of powers and history, I think that maybe has it exactly backwards, that Congress needs to specify either more careful substantive limits or more careful budgetary constraints. I think if you turn back to the Sinking Fund Commission, what Congress did when it wanted to make sure that the executive complied with laws is that it used officers who were not removable by the president to make sure that they would stay in the confines of the law. So I think that is a very different answer, I guess, than the one proposed by non-delegation. But if you look to the Sinking Fund Commission, I think that is the answer that was not only chosen by the first Congress, but also was one proposed by Alexander Hamilton, even though he was generally a proponent of a strong executive. Here he was worried about the executive staying within spending limits or actually spending money to pay the debt on its intended purpose rather than a tax break or some other more popular item. And the way to achieve that, again, was to make sure that there was insulation from politically accountable actors.
Just a quick response to the Treasury point, and then quick-ish response on the spending as executive power and non-delegation question. On the Treasury, I just want to agree, like, it must be the case that it's all public funds in the sense of, where were when Andrew Jackson withdrew the deposits, where were the deposits? In the US Bank, where were they after? Well, in all the Democratic, Republican banks in the various states, and for the next 60, 70 years, whenever there was a new election, the money was transferred to the banks owned by the political party, the allies, right? I mean, so it's wherever the money is, the second the CFPB makes, the Federal Reserve makes interest, that is the Treasury of the United States. And they can cut a check, or Treasury can cut a check to the operating account of the CFPB. That account is the Treasury of the United States. There's no secret vault in Fort Knox where all the treasure of the United States is just hidden. And so I actually don't think money is withdrawn from the Treasury until it leaves government hands and goes into my personal bank account as the employee of the government or the contractor of the government or whoever we are paying to do things for whatever that's worth. So I agree. On spending executive power, it just maybe it was, but lots of things were executive power that were given to Congress, right, as we know, and including this. So I think John Harrison is right that there's some concurrent power to manage the resources of the government in the absence of statute, so you can invest it, I suppose. Okay, I don't think you can give it away or give it to private party. I don't think you can necessarily sell public lands. And in addition, if it was executive power, it was given to Congress, right? And the needful rules and regulations for the property, for the territory, and I'm missing something, but also property, right? And so that the next point to make is the appropriations clause itself. We all think of it as a limitation on the executive. This is really a question to everybody. But why? It's in Article 1, Section 9. When Lincoln suspended habeas corpus, we think it's unconstitutional because the suspension clause is a limitation on Congress. So it'd be weird. But then it says the appropriations clause limitations on Congress, but it would just seem to be a circular problem because Congress can just appropriate and then. So it's weird. What work is it doing there? But again, it's a suggestion that it's a limit on Congress and this power to spend comes from Congress. So maybe going back to Chris Green's point at the end of the day on the non-delegation question, it's just when it comes to spending, I mean, not only is it, if it's incidental and can be implied, then it's less important. But at the end of the day, one view of non-delegation is Congress can only do as much as is reasonably practicable for it to do. And when it comes to negotiating interest rates, to take another paper, excellent paper from Christine. That was your paper too, right?
It was,
yeah.
yes.
The delegation of power to negotiate interest, and to spend money, and you can't do that. You can't specify more than that, right? Because some things you just don't know what the market conditions are going to be, and this might be a similar example.
Great. Our next group of three consists of Tom Colby, Joel Alcia, and myself.
So great paper. I think you're definitely right that the Fifth Circuit's argument against the funding mechanism for the CFPB just doesn't work as a matter of originalism, and I think you bring to bear new evidence to defend that and strengthen that conclusion. I think that's great. My question is, maybe I just sort of asking for your thoughts on something. I attended the oral argument in this case, and something jumped out at me during that argument, and I wanted to get your thoughts on it. What jumped out at me was that what Noel Francisco was really doing was making a challenge to the funding of the CFPB as a separation of powers functionalism argument, right? That he's saying, really, yes, it's true that the funding of the CFPB technically complies with the formal terms of the Constitution. The appropriations clause only requires an appropriation by law, and there was one here. Yes, okay, but when you combine all the various ways in which this funding mechanism is unusual, what you end up with is you're tipping the balance of power between the branches of government in a way that sort of collectively is maybe unprecedented and undermines the functioning of government. Especially Noel is making a big deal, an argument that the cap that's put on this is so high as to be almost theoretically irrelevant. The discretion to take as much or as little as you want is really left entirely with the executive branch. And it's funding in perpetuity that can only be taken away if you got basically a supermajority in both houses of Congress, because you've got a presidential veto that has to be overridden. So as a practical matter, you've just taken this entirely away from the legislature and put it entirely in the hands of the executive. And it strikes me that that kind of argument might have sold the Supreme Court a generation ago, with Justice Scalia writing a very angry solo dissent. But today's court is all about formalism, not functionalism, and separation of powers. It's a little ironic that Noel Francisco is up there making an argument to the Supreme Court, arguing a case that can only be won with functionalism, and he doesn't make it in functionalist terms, in part because I'm sure Noel would kill himself before he ever did, but also because it wouldn't work. He's not going to sell the Roberts Court with overt separation of powers functionalism. But what he's left with then is this originalist, formalist, textualist argument that simply doesn't fly. And maybe he gets Alito's vote. At the end of the day, I think he loses 9-0. And so I'm just curious your thoughts on that.
Thanks, Christine. Great paper. I think very compelling on the appropriations clause argument. But as you acknowledge in the paper, last summer, my colleague at Catholic University, Chad Squitieri, made the argument that the right way to think about this case is through the necessary and proper clause. And in that paper, he argues that you have to think about what clause of Article 1, Section 8 is justifying, what power is justifying the particular expenditure of money at issue here, right? So I took your response earlier in responding to Ilan's comments on necessary and proper to be, well, look, my history here shows that it doesn't matter where you ground the CFPB's funding authority, because of the sinking fund example, that just shows that it's constitutional, right? But I don't think that's fully responsive to Chad's point, because he's saying, well, the scope of permissible funding authority and discretion would depend on what Article 1, Section 8 power you're grounding the CFPB spending authority in, and therefore the extent to which it's necessary and proper to carrying out that power to allow discretion in funding mechanisms, right? So I don't think that you can just give a one-size-fits-all kind of argument that, well, if it was okay for the sinking fund, it's okay for CFPB, because they might be justified on different Article 1, Section 8 bases, which would have different amounts of discretion in terms of funding authority. So I just wanted to push back on that and see if you had a response to Chad's argument on that point.
Well, that's actually a good segue to my question, because I was going to ask you also about the Sinking Fund Commission. You are discussing it in relation to a spending power and also to the appropriations clause, but furthering on to what Joel just said, it seems to me that it's arguable that a better reading of what went on in that situation is that Congress was carrying into execution an implied power, a specific implied power, which was the implied power to pay the debts of the United States. And there's a lot of evidence in the founding era that the founders thought there was such a power. The best example of which I'm aware is the case of United States against Fisher, 1805, in which the Marshall Court upholds a provision of a bankruptcy act which places the United States permanently in first position among all creditors in any bankruptcy proceeding. And it's the first necessary and proper clause case, so it's well known for that reason. But what Marshall actually does in that case is to say that Congress was exercising its choice of means to carry into effect a specific power, and the power is the implied power to pay the debts of the United States. That's a nice case for someone like me who likes implied powers, but I think it's potentially a problem for you, because it would mean that you can't, as was just suggested, you can't necessarily draw generalizations from the Sinking Fund Commission example for something broad like the characteristics of the spending power and what kinds of things can be done under the spending power, because what was actually being done with the Sinking Fund Commission, it seems, was the carrying into effect of this specific, widely recognized and well understood implied power to pay the debts of the United States.
All right, thank you so much. So on the first question of the oral argument, and is this just separation of powers functionalism, maybe I thought Noel Francisco kind of didn't stick with a consistent theory between his briefs and his arguments. It was kind of difficult to discern at some level. So, but to say, like, he was ultimately saying there are multiple layers, I think. His better argument, I guess, would be there are multiple ways in which the commission is given discretion over its budget. It can self-direct the amount of its budget up to some capped amount, 12% of the Federal Reserve proceeds. It also has indefinite power over that. It's not time-bound. And the third factor would be that those proceeds come from, not directly from annual appropriations from Treasury, but from interest that is drawn from securities that are held by the Federal Reserve System. So those would be the three elements. And again, I just think they're on a functionalism argument that this is a very underwhelming case for Leviathan. I mean, $600 million is about half of the Federal Reserve's budget. It's not that great of a budget. The fact that it doesn't spend up to a cap, I think Justice Kagan answered pretty well, is like, it's a new agency. Maybe it's just getting started, and doesn't the Supreme Court sometimes not spend all of its budget? Isn't that admirable rather than something that should create a constitutional violation? So I don't see it on a strong functionalist argument. I kind of wondered if, maybe is there, like, what's the best argument? Could somebody make a stronger, case for there being a a violation of the Constitution based on some type of spending that was too broad? This is an example brought up of, I think, what if Congress passed a law that said the executive branch can have forever $1 quadrillion to spend on anything unrelated to the Army? Would that be a problem? I think General Prelogger's response was, well, that's not this case, but maybe that would be a problem. Maybe that would align with something Montesquieu pointed out as a law that hands off spending power to the executive forever is one that essentially cedes that power, or be amending the Constitution, I think, to the extent Congress has the spending power. If you pass that law, maybe that's trying to amend the structure of the Constitution. I guess I just think as a functional matter, I don't think that the Consumer Financial Protection Bureau came close to that, and I think there are a lot of examples from the founding era where there's broad discretion given over spending, but they didn't come close to that type of violation. And then in terms of thinking about, and it's great to bring up, I really enjoy Chad Squitieri's work. He's always somebody who gives a new, interesting perspective, I think, on a lot of separation of powers issues. So, under the necessary and proper clause is our evidence of what might be necessary and proper historically something that needs to be kind of channeled to look at each particular, type of power that's being exercised. And I guess my answer is no, based on the appropriations clause. I mean, when Congress was worried about specific limits for spending over a particular power, it was worried about the Army, and it imposed that 2-year limit expressly. Otherwise, textually, the appropriations clause is one that talks generally, and it doesn't have that limit. So I think it's not differentiating, I guess, between exercise of the commerce power versus exercise of the power to pay the debt or borrow money, et cetera. So I just think, sometimes the efforts to kind of to segregate too carefully, historical evidence from certain parts of the Constitution might put too fine a point on it. And in this particular case, again, the appropriations clause uses general language, and I think that's what is reflected here. And then I guess the last point about, again, is the Sinking Fund Commission, because it is paying the debt, is that something, doing something different in this realm than we might think about other types of actors for matters of separation of powers? And I guess my answer is no. I mean, the executive power encompasses the executive power in general. It doesn't say the executive power when it's assigned with respect to paying debt, or it's not segregated or narrowed in that fashion. So I guess I would say that, and again, legislative powers, there are different legislative powers herein vested in Congress, but when it comes to appropriations, the language on that is general. So I'm not really sure that we should be trying to chop up or segregate the historical record in ways that don't really track understandings that appeared to be shared by the framers.
Great. In reading your article, I was thinking that maybe I'm misunderstanding it, but it seems to me that the most compelling problem is the question of delegation of the taxation power. It's the coercive aspect of raising money. The sinking fund issue isn't a problem. Congress sets up a business and then just says, go for it. And then operate like a free market, or market like an entity on the market. But you've got a presupposition, no taxation without representation. You got the English Bill of Rights that says basically not one dime can be levied by the king without an act of parliament specifying the levying. And with the regulatory agencies, and they mention this in the decision, they don't mention it as much as I would like, and that is they have a lot of other types of power, including the power to establish the rules that define the fines, and have effectively coercive fees. So there's all this coercion being taken, and then they take the money and they don't do it. So it's the delegation of the taxation power to these entities. And the second is the absence of a common treasury. You mentioned earlier the articles. Article says that there shall be all expenses shall be out of a common treasury. We want to put all the money together so we can see what's going on. At any rate, that seems to me maybe that's not really what's driving some of the concern here, but it's my concern.
I am very persuaded by your paper, but I'm a little nervous about what I'm persuaded into. So I feel like we've heard three sort of different things. Like on one version, there's no non-delegation problem as long as there was some non-delegation doctrine at the founding. You had to have some intelligible principle, but if you had, there be some kind of but if it related to spending, you were in the clear, right? So that's box one. Box two is, I think I've heard you say that Congress can spend whatever it can appropriate very broadly, as long as some purpose is specified. That would satisfy any intelligible principle requirement, but there's no ceiling. Box 2.5 is there is what I just said, plus there is a ceiling, but the ceiling is something like $250 billion because that's what we saw. And then box 3 would be you have to do all the things that Hamilton said, right? You have to do purpose and limit and source, and only then is it all right. So I just wondered if it would be worth in this paper just specifying where you think the outer limit is, because unless you say something like that, I don't understand why you could say that the quadrillion-dollar hypothetical is out of bounds.
Thanks. So this does not require a response necessarily, but I'm just kind of interested in the decision about kind of where you start and where you stop, because you kind of pick up the story of your historical recounting mostly with the Constitutional Convention and then focus mostly on early federal practice, which I think is probably, I think most of us in the room are probably persuaded as a critique of the Fifth Circuit, but to get a really comprehensive answer to these questions, there's a lot more that I would think would be relevant, right? English practice, whether early state constitutions had similar restrictions, practice under the Articles of Confederation. I'm interested in kind of, your thought process and sort of how you said, okay, I've got enough to go forward. And then also if you've looked at that other universe of materials and whether it has any bearing on some of these broader questions about non-delegation, other things that people are bringing up.
All right, thank you. So in terms of the look at not only spending, but also what about these fees that extract money from a private citizen? I guess there is a law on the books that Congress has specified, and that was actually important in the founding era because historically, when we had these fee-based regimes where, like, the customs officer could say, okay, if you want to import goods, my fees are X, Y, and Z. Historically, they would ask for kind of like a bribe on top of the officially sanctioned amounts. And one of the things that Congress did in early legislation was specify and actually allow people to seek penalties from officers who tried to charge in excess of the posted amount. So they wanted to confine these officers more narrowly to those kind of posted fees in that sense. So I think there was something authorized by Congress. I guess for me that raised, I knew I was probably not going to get out of this without saying something about Chevron. So one thing I'm curious about in Loper-Bright is I think there was a statute that it delegated some power, but it didn't necessarily, the executive was the one who maybe got to choose choose to impose fees on a private party. I'm not sure if anyone has actually briefed that or not in Loper Bright, but to me that seems like a different case and one that might be more problematic in terms of Congress not authorizing that type of extraction of money from a private party, but I don't think that is what is happening in the examples that I have in my paper. And then Mila, great points on kind of making clear the limits, and I guess I do think there are limits on what Congress can do, both in terms of the kind of substantive limits for a delegation of power to the executive branch and on spending. And I do think that the basic principles of the purpose, the limit, and the source of the fund are important ones. And here, maybe something that I could drive home more is that there are limits, right? The CFPB has capped funding. At the founding, there were limits either as a matter of kind of like dollar amount imposed. Now, it might be a very generous limit, like $250 billion, something that you would not be able to spend, but for multiple years, that's a generous limit, but it is a limit nonetheless. And I think also, the idea that some of these, fee structures, so for example, the, customs officers didn't necessarily have an overall cap on the amount of fees that they could collect, but it was usually a fee for per forfeiture sought or fee for action performed. So implicitly, I think there's some cap on, nobody's going to get rich being a customs officer, basically collecting those fees. So I think in that context, there's not a cap, but there's how many of those fees, or maybe the better example would be the U.S. attorneys who could get this like really nominal amount for per prosecution brought or per conviction won. So there are limits, I guess, there as well. And again, Congress was scrupulous about making sure the amount of the fee charge did have to be limited by statute. And then I think I come out that the intelligible principle for substantive authorizations is not that far off from things that were understood at the founding, and that should be the standard for substantive authorizations. And I think that intelligible principle would be something that would relate to basically the purpose of the spending, or should specify that. So the example I gave where it's, executive, use this money to do whatever you want except for spending on the Army. Well, is there a purpose there? Not really, maybe don't touch the Army, but I don't know if there's any other purpose or intelligible principle you could derive from that. I guess that there is a limit, $2 quadrillion. That's a very large limit, but it is still a limit. So I think that's helpful to kind of think about. There are some limits. I guess I just don't think that those outer limits are ones that are approached in either the examples of the historical record or by the Consumer Financial Protection Bureau. I think, ironically, the agency that's probably more of a concern beyond the Consumer Financial Protection Bureau is the Federal Reserve's own funding. I think there they get to draw from the same source, whatever funds they find sufficient, or I think for the local or the regional Federal Reserve banks, funding that they find necessary. So that's a much more open-ended limit, probably still supplying an intelligible principle. And then great point in terms of like what evidence should be considered. I'm all for holistic examination of the historical record. Here, I think there were some specific parts of the record that were missing. People, and in terms of, I would need a book, I think, to canvass everything that should go in to that more comprehensive view of the historical record. But here, I do think the parts of the record that the Fifth Circuit was missing and that I brought to bear are ones that are probably at least enough to question the Fifth Circuit's result in this particular case. And I do think, before someone finds a statute, unconstitutional, you might think carefully about the burden of proof, and it should be pretty clear evidence, right, of something that is in tension with an original understanding. And here, I just don't think that that particular burden was met.
Great, thank you. So with apologies to those still on the list, I'm afraid we're out of time. I will just mention as a conversation starter over cocktails that they are Ethan Yan, Lorraine Updike-Toller, Bill Traynor, and Richard Primus. So maybe find them and ask them what their question was going to be. Thank you, Christine and Ilan. Please join me in thanking them.